So you're telling me this test that showed up positive, you didn't use cocaine?
Which one?
The 20th,
The 20.
last
no,
test.
No, I had.
You had
Fifth
not
to
used
fifth.
any cocaine,
No,
even though you've been using it for years.
right. Right. It should have been clean. I'm saying, I don't understand why it was dirty. But the problem is this, sir. You guys don't check the levels. So you,
Oh,
I
can check levels.
wish
But
y'all
not
would.
about, well, I can get the levels.
Okay.
That's not a big deal.
Okay.
The problem is because you missed the test,
Uh-huh.
if you did a little bit of cocaine, it'll look like it's going down, but you didn't use cocaine still.
Oh.
You should not be testing positive for cocaine 2 weeks later.
Fast-paced docket, multiple defendants, and rapid-fire decisions open this courtroom session. From waived prelims to adjournments, judges and lawyers push cases forward. Watch for strategy, pressure, and consequences hiding between routine words. Subscribe for dramatic breakdowns. Like, share, and stay locked as twists unfold across the entire morning calendar today.
You were standing up. Come on up. Oh, somebody. I need.
Don't all jump up. Right. We're starting strong.
Yes, we are.
Your Honor, Ms. Cannon is having some stage fright. Michael Gaddy from the Washington County Public Defender's Office. Your Honor, to the extent that there's a conflict, we would waive any conflict. When we agree with the prosecutor, we'd ask the court to waive any conflict or any potential conflict or thought of a conflict in these matters.
And the court for its part does not believe there's conflict either under Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Kenyon Jackson.
Al Chavalowski for the People.
David Goldstein appearing on behalf of the defendant.
All right, Mr. Jackson, can you state your name, please?
Hey, Al Jackson.
Thank you, sir.
Your Honor, Mr. Chavalowski and I have had an opportunity to discuss these matters. This matter is going to have to be sent. These matters are going to have to be sent to circuit court for resolution. My client was unaware of that because he's in the Macomb County Jail. But Mr. Jackson, we're going to work out a deal for you in circuit court, just like we did in Macomb. So we need to waive exam, just like we did in Macomb. Is that okay with you?
Yes.
All right. So, Mr. Jackson, you understand that you're waiving your right to have a preliminary examination in these matters?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing on these matters and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on all charges.
Your Honor, we acknowledge receipt of informations in both files. My client waives the reading, stands mute, asks that a not guilty plea be entered.
Trying to find the case. I have 4 counts on the case. I have 4 and 3, correct?
Correct.
All right. Defendant having waived formal reading, standing mute, the court will enter a not guilty plea as to all 7 counts. Pretrial in this matter will be set for
February 23rd at 1:30 before Judge.
February 23rd, 2026, 1:30, Judge Hamoud.
Sorry, Judge.
Hamoud.
I thought you said Judge who?
I did not call
It's
it.
going to be one of those days, Judge. It's going to be one of those days.
All right. Bond will continue.
Thank you, Your Honor.
Court calls the case of the People versus Demarion White.
So. Morning, Your Honor. Please have a court David Burgess on behalf of Marion White, who's appearing via Zoom from the Juvenile Center, Your Honor.
Mr. White, can you state your name, please?
Demarion White.
Thank you.
Your Honor, myself and Mr. Childers are working toward a resolution. It's probably going to get bound over eventually, but we need a little more time at this level. So we're just asking for a couple weeks adjournment, Your Honor.
12. Probable cause conference will be adjourned to February 12th,
Thank you.
2026, 9 a.m. Bond continued.
Thank you, Judge.
Thank you, sir. Court calls the case of the people versus Margaret Petowski. Yeah. Petowski? Yeah, she's in Zoom, I think, but I need an attorney.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Ms. Petowski.
Ms. Petowski, can you state your name, please?
Samuel. A case law in there, because everything else was.
Ms. Petowski, can you state your name?
Margaret Petowski.
Thank you. There you go.
Your Honor, there was an offer
Thank you.
made in this matter, and I did meet with Ms. Petowski at the Department of Corrections yesterday, and as soon as I left the department, was able to leave the department and get to my cell phone, I did reach out to Mr. Childers to let him know that she intends to accept the offer. Unfortunately, I don't believe he received it in time. It was like 4 o'clock, although I had a 1:30 appointment.
I'll then adjourn this out 2 weeks to the 12th, February 12th, 2026, 9 a.m.
And I apologize, Ms. Petowski. I know you.
The bond will continue, and hopefully then I'll have the paperwork and we can get it all settled. Okay, Ms. Petowski?
Okay, thank you.
All right, thank you. Court does call the case, People versus Procopio Vitale.
On behalf of Mr. Vitale, good morning, Judge. Good morning. Mr. Vitale will be approaching. Please state your name for the record once you get up here.
Procopio Vitale.
And if you wouldn't mind just signing here.
What are we doing?
We're on today's date, time set for probable cause conference. We will be waiving the preliminary exam at this time. Mr. Vitale is executing a waiver form right as we speak. Handing it to Deputy Allen.
Is that correct, sir? You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution. I do. All right, people also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Stand mute as to reading or waive. I got there eventually.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for February 12th, 2026, 1:30, Judge Slay.
Okay, thank you, Judge.
Bond continued. Thank you. Calls case of the People versus Tiffany Peters.
First major move matters. Waiving a preliminary exam sends charges straight to circuit court. That choice trades testing evidence now for negotiating later. It can speed deals, but raises risk. Would you waive probable cause scrutiny to chase leverage, or demand the hearing and force proof before prosecutors reveal their hand?
Go on behalf of Ms. Peters. Judge, it's a turn AG case.
I think it's an AG case.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Judge, this is a PCC matter. I had a long,
Want to state your name?
oh, I'm sorry, Robert J. Kill on behalf of Ms. Peters. Sorry about
Ms.
that.
Peters, can you state your name, please?
Tiffany Comer Peters.
Thank you.
Judge, Ms. Peters is living in West Virginia now. This is a child support matter. She's current in her payments as far as monthly payments. I'm asking for a 30-day adjournment. Again, I had a long conversation with her last night. She can make between now and then, within the next week, she can make an $800 payment. And we're hoping she can bring this amount down to where we can work this out short of a felony, but we need some time to do that.
Gonna be any objection from the people regarding that?
No, I would just like the attorney to get in contact with our office, but no objection, Your Honor.
Gonna call their office.
If I know who to call. Yes, I will, Judge.
Thank you. Probable cause conference will be adjourned then to February 26th,
Thank you.
Thank you, Judge.
2026,
Thank you.
9 a.m. Bond.
Thank you. Appreciate your consideration.
Courthouse case of the people versus Gary Cartwright.
David Eichel, appearing on behalf of the defendant. State your name here.
Gary Carmichael, thank you.
Setting this matter for exam, Your Honor. I do have all the discussion.
Okay. People have their witnesses available to 10
Your Honor, I'm going to be gone the month of February.
the whole month.
Yes.
That's right. He held on something else?
No, Your Honor. I was going to make a bond motion in a moment, Your Honor, but
Are the people going to be opposing a release in this case?
I would just ask for a tether as well as a potential silver.
Okay, here's what I'll do. Will March 3rd work for you?
Your Honor, I've got a trial starting on the 2nd. I can do the 10th.
So what I'll do is preliminary examination in person, March 10th, 2026, 9 a.m. before Judge Washington. What I'll do at this point is I'll have his bond continued. You two send a stipulation over with the conditions and then I'll sign off.
All right, thank you.
All right.
Thank you.
Thank you. Court calls the case People versus Randall Laird. AG.
Morning, Your Honor. Assistant Attorney General Chris Williams on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Dodgy Lebo on behalf of Mr. Laird, who I believe appears by Zoom. Mr. Laird, please state your name, sir.
Yes, sir. Randall Laird.
I need a camera, sir.
I'm working on it. I'm sorry.
What are we doing?
In regard to requesting an adjournment, I did just receive full information on the potential offer this morning, which I'd like to review with Mr. Laird.
I put that on the AG case. 26. Yeah, let's do it that way. All right, probable cause conference in this case will be during February 26, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you. Case People versus Andrew Patton.
Oh, that was it, I guess.
Yeah, that was it. Unless you want me to do something else, but people normally don't. Thank you, sir. All right.
Good morning, Your Honor. Charlotte Steffen on behalf of Mr. Patton.
Mr. Patton, can you state your name, please? And just Mr. Patton. Thank you. What are we doing?
Your Honor, we have reached a resolution of this matter. Mr. Patton is signing the plea form and the advice of rights form. The people have offered to reduce this to the use of cocaine, a 1-year misdemeanor.
He's going to plead guilty to that charge.
Yes, he is, Your Honor.
All right, the plea form that I have in front of me now indicates that the defendant will be pleading guilty to the charge of use of cocaine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed.
That's correct.
That's the court's full understanding of the agreement. May I have it sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Andrew Spencer Patton. Sir, it is this court's understanding that you're gonna be pleading guilty to the charge of use of cocaine.
Yes, sir.
That's a misdemeanor punishable by up to 1 year in jail and a $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case.
Yes, Your Honor.
And that you would be sentenced before Judge Perry in the 15th District Court. You
Yes, Your
understand that? Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody promise you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce
No, Your Honor.
you? You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
because you believe that you're guilty?
Yes, Your Honor.
May 16, 2025, at the location of North of Huron Street, City of Ann Arbor, Washington County, State of Michigan. Did you have cocaine in your possession?
Yes, Your Honor.
Had you used it?
Yes, Your Honor.
And did you know what you were using was cocaine?
Yes, Your Honor.
Sir, if I accept your plea between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No. And have I complied with the court?
You have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be February 27, 2026, 8:30
Your Honor, may I address bond?
before Judge Perry as to bond.
Thank you, Judge. Your Honor, Mr. Patton is in custody on a bond violation for failure to test. It's my understanding that he was reporting as directed, but didn't have the funds to test. He also believes there was some discussion at the time that the bond was set, indicating if he was not able to afford testing, that he would not be in violation. So we are respectfully asking if Your Honor would reinstate the bond. Thank you, Judge.
Any response from the people? Are you going to be able to test?
Yes, sir. I mean, I can't afford it, but I can test clean. I can't afford it.
Well, you're gonna have to find a way to.
I can find a way.
to test. Because if I let you out, we're gonna end up in the same boat again. If you don't go over there and don't test.
I can go test. I can either pan out or do something to make that money up, but I can, yes, sir.
I'll grant the motion for a bond reduction. Previous bond is reinstated. with
Thank you,
its
Your Honor.
conditions.
Thank you, Your Honor.
A contradiction lands hard when defendants explain missed tests, money issues, or lingering substances. Judges listen, then probe timelines. Excuses shrink under follow-ups, and credibility becomes the real charge. Tension spikes as stories collide with records, and outcomes hinge on trust evaporating right now inside this packed courtroom drama today.
Thank you. This is what I need to do. CC. Just want to put back to her. Court does call the case People versus Michael Padola. Yeah, I see him. Here's his attorney. Who's his attorney? Mr. Bennett? Really? Mr. Bennett? First state your name.
Michael Bedolla.
I'm gonna pass your case. You gotta wait for your attorney to show up.
Okay.
He's on the Zoom screen, but not responding. All right, I'll pass that case. Court does call the case of People versus Candida Cadena, self.
Your Honor, I'm sorry, did you call the dole? No, you didn't.
Good morning, Your Honor. Christina Saxon on behalf of Mr. South. Please state your full name for the court. Kadena Gilso.
Thank you. You're requesting an adjournment.
Yes, Your Honor.
You're waiting. You just got appointed. You're waiting video discovery.
Correct.
Is that on its way?
It should be heavy, Your Honor, so it should be.
Probable cause conference will be adjourned then to February 12th,
Your Honor, I'd like to make a bond modification motion.
February 12th, 2026, 9 a.m. Yes, Mr. Bond.
Your Honor, Ms. Self is being held on $1,000 cash bond. I'm asking for a reduction to a personal bond. It's reported to me that she and the alleged victim do not reside together. He has a different address, so she should be able to return home. And or may not be able to see. She does have a cast on that she will need to go to a physician to address, and being incarcerated, I'm afraid that she won't be able to do that to get it off in a timely manner.
Response.
Your Honor, at this point, I would object on our bond bill. We requested 25,000 cash security. This involved Ms. Self stabbing the victim. It involved a screwdriver hit by a puncture wounds that officers saw. She was also very irate and aggressive at the scene when officers arrived and were berating the victim and then had to be carried to police car. So I expect that this could potentially be other charges in the future for RNO, but at this point, I would object.
Anything else?
Yeah, I would just say that it was a highly intense situation, and berating, calling someone names does not rise to the level of incarceration. I believe, or additional charges, calling someone names isn't enough.
With a
But as for that's,
stabbing with a screwdriver, that would do it, wouldn't it? You don't need to say anything.
just
Motion for
stressing.
bond reduction denied. Bond will continue. Thank you. She's lucky I won't raise it at this point. Court calls case People versus Edna Grima.
Good morning, Honor. Charlotte Steffen on behalf of Ms. Karma.
Good morning.
Your Honor, we're requesting an adjournment for discovery.
The adjournment. You might, have you seen the progress report?
Yes, I reviewed it with my client this morning, Your Honor.
Why do I have cocaine showing up in her system?
Because, sir, when they test over there, they don't do it the levels. So I've been getting high for 48 years.
What?
Yeah. And so even though it was like, I think the last time was like New Year's Eve or January 5th, one or the other, but you don't show levels, so you don't show it going down, down, down. And therefore, if you got cocaine in your system, you just got cocaine in your system. That's how it is, but that's not okay because it could be in my system for a long, long time, even though I don't get high.
Okay, so just so I'm clear what you're telling me.
Yes.
That on January 5th, you tested positive for cocaine. And that was just,
And I didn't
that was just
expect
something in
it
your
should
system.
not have been.
It shouldn't have been there.
Right.
It's just stuck in your
But you
system.
guys don't do
And
it
then-
by levels.
What?
You don't test it by levels to see if it's going further and further.
Okay, so then the next time you're supposed to test, you missed the test.
Huh?
Then you missed the test.
Oh, I didn't have $12.
Okay. And then the next test, almost 2 weeks later, you're testing and you test positive for cocaine. And so, hold on before you, because I want to make sure I've got your story. And so you're telling me that the second test for cocaine was really the same as the first test because it's just stuck in your system because you've been doing cocaine forever.
What
I
I'm
don't know
saying,
who the heck you are, but if you start yelling in my courtroom, you're gonna be going with her.
okay, this what happened on the 5th, to be honest.
What? What happened on the 5th?
I said that, wait, what happened? Let me think.
I don't know. Go ahead, think about it.
Near final words, rulings clarify direction. Pleas accepted, counts dismissed, bonds adjusted, or cases bound over. Each decision reshapes risk, custody, and leverage before sentencing. Dates lock in momentum, judges warn consequences, and the procedural chessboard resets for circuit court battles ahead, where negotiations intensify and pressure multiplies quickly. Next.
Right. What I'm saying is, on the 5th, I was dirty. I had used, like, not that far from there. But I was scared to say so because I was scared to say so. So then the next time I didn't have the $12. And the next time
So
it was
hold
still
on. That's what I was getting at before your fans started yelling out from the.
my sister. She here
Yeah,
from
all right, but
out of town.
so you're telling me
Mhm.
this test that showed up positive, you didn't use cocaine,
Which one?
the 20th,
The 20.
last
No,
test.
no, I had.
You had
Fifth
not
to
used
fifth.
any cocaine,
No,
even though you've been using it for years.
right, right. It should have been clean. I'm saying, I don't understand why it was dirty. But the problem is this, sir. You guys don't check the levels. So you,
Oh,
I
can check levels.
wish
But
y'all
not
would.
about, well, I can get the levels.
Okay.
That's not a big deal.
Okay.
The problem is because you missed the test,
Uh-huh.
if you did a little bit of cocaine, it'll look like it's going down, but you didn't use cocaine still.
Oh.
You should not be testing positive for cocaine 2 weeks later. That's the bottom line.
So
Grant an adjournment in this matter to February 5th, 2026, 9 a.m. That's 1 week out.
Your Honor,
You're
I'm
not
not a-
available that day?
correct.
That's fine. I'll set it on the 12. At this point, the defendant's bond's revoked. She's remanded.
Damn.
What'd you say?
Excuse me. I was saying my sister.
You know, you need to take yourself on out. What? What last one? Oh, was it?
Want me to repeat it?
No, that was. You don't get that response. No, she's good. What? You don't talk to me about that? No, okay. Court does call the case of People versus Terry Probst.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Probst, who's making his way into the courtroom, I would assume.
Well, where is he?
He is in custody, Judge.
Oh,
Just give that back to you. Yeah.
we'll pass it.
Okay.
Court does call the case versus Quan Patterson.
Freeman Cook. Cal Kavalowski, the people, Your Honor.
What? Who's that?
That's Mr. Probst.
Oh, I'll just take him if you got him. All right, back on the Probst matter.
Morning, Your Honor. Raymond Cook.
Okay, sign there. Michael Gaddy, Assistant Public Defender, on behalf of Mr. Probst, Your Honor. State your name.
What are we doing? Thank you, sir.
Your Honor, these are going to be waivers. I have gone over his rights. He's executing the form now. I've gone over
Sir,
with Mr. Probst.
You're waiving your right to a preliminary examination. You understand that that's a proceeding where the people would have to show by probable cause. Alleged to have committed it.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further
Yes, sir.
resolution. People also waive their right. Yes, go ahead. All right.
That is correct, Judge.
Preliminary examination having been waived in both of these matters. Defendant is bound over to circuit court.
Your Honor, in terms of arraignment, we'd waive reading, stand mute, the charge.
Defendant having waived former reading, standing mute, court will enter a not guilty plea. Pretrial will be set for February 11, 2026, 1:30, Judge Conlon.
Your Honor, if I could be heard on bond.
Yes.
Your Honor, I've had a chance to speak with Mr. Probst about this. I've reviewed the file. Mr. Probst was remanded at his last probable cause conference. He had missed some tests and had tested positive. The positive tests, looking at the violation, were from when he was first arrested. He reports he got a personal bond sometime around December 29th. The missed tests, he reports resulted from a stay in the Wayne County Jail where he was, obviously unable to test. He then reports having gone to community corrections. They indicated that they did not have any record of him needing to be there, and that's why he didn't test on the 29th. I'd ask the court to release him. He does report that he does have a place to stay in gainful employment. I have reached out to he gave me a number. I've reached out to the employer. They haven't gotten back to me yet. So, but that's kind of where things stand, Judge. He reports that he would test regularly in this matter.
That's not what my file reflects, his rendition of things. Most for bond reduction tonight, bond will continue. Thank you,
Judge.
Court calls case People versus Quan Patterson.
Is that Mr. Goldston there?
No, Mr. Boulevard.
Oh. Okay, then. Mr. Kilowatt is on Zoom in another court.
Who?
Or, I'm sorry, Mr. Goldstein is, sorry. He's trying to wrap it up, so he's not gonna be able to come in for a couple of seconds.
Is this Klein here?
Yeah.
Oh, okay.
Klein is here. And I don't have stage right.
Why are you sending as the messenger? You wouldn't even stand up at the beginning of the docket. Now you're delivering a message. No, I don't want to talk to you. Bye. Court calls the case of the People versus Bradley Potter.
Alan said on behalf of the people.
Ron Brown Train on behalf of Mr. Potter. Mr. Goldstein standing in for Mr. Fikowski.
Seriously? Okay,
That's what-
no.
You want me to go get him?
The one you were delivering messages for.
Tell him Bradley Potter's up. Sorry.
Your name, sir? Bradley Potter. Thank you. None of this is your fault. This is.
Goldstein standing in for Mr. Fikowski.
Do we know what they're doing?
Setting exams,
Setting it for exams?
both of them. Mine
Okay,
too.
so based upon your knowledge, the discovery is complete.
That's my information.
And so you want your matter set for exam? Is that what you're
Yes,
talking-
sir.
All right, very good. Would the people have their witnesses available to 10? Preliminary examination will be set February 10th, 2026, 9 a.m. before Judge Garwood.
Hey, I just said it for you.
Okay. Bond will continue.
It's February 10th. Judge
Thank
Garwood.
you. I'll tell you. And, all right, thank you, sir. We already took care of it after we got the message from your messenger, Cannon.
She couldn't do the waiver of.
That's what I was saying, but she was delivering messages for people. I don't know what her deal.
Judge, can I approach in a related matter to this,
To which one?
Mr. Fikowski?
Oh, sure.
I'm standing in for him today, Your Honor.
Recall the case of People versus Quan Patterson. Did I finish Quan? Quan Patterson.
David I. Goldstein, appearing on behalf of the defendant. Wants
Your
to-
name, sir? Paul Patterson. Thank you.
Your Honor, we do have all the discovery, including the videos. We're asking the matter be set for free.
People have their witnesses available the March 10th. Yeah, that's what I said. Is there a problem with that?
I hear it most of.
Your Honor, if I could address bond,
Go ahead.
if I can address bond real quick. My client, the magistrate, for whatever reason, saw fit to place a tether on my client, a GPS tether. It's not a curfew. We're not sure why exactly. He wasn't ordered to do any testing. I've known Mr. Patterson for a number of years. He's a lifelong resident of this county. He is not a risk of flight. He works in this county. He lives in this county. He has family in this county. So we're not sure why the magistrate, I wasn't present at the arraignment, Your Honor. Not sure why he did it, but we're asking the
Do you have
question.
anything else pending?
No, Your Honor. No. And all I can say about this particular case, Your Honor, is I think whoever the judge at the prelim is going to find the video very interesting.
Any response from the people? Those ears, no, go ahead. I didn't know if it was the ears or not. Go ahead. What?
I think that there was, the tether probably was related to, some recent, at the time of charging, some recent cases that, have been pending or were recently dismissed as exam. There and prior history, I don't necessarily have any other explanation.
That's
So
correct.
You're indicating at the time that the arraignment happened, there was other stuff pending.
Right, which was then subsequently dismissed.
That's what I.
Got it. Okay, with the understanding that there's been a change in circumstance on this, I'll grant the request to remove the GPS tether. So we'll prepare an order and let them know so you can get that removed even before you leave here. Just go over. Okay. I'll set preliminary examination in this matter, March 10th, 2026, 9 a.m. before Judge Garwood. His bond and its monetary amount will continue without fee.
Thank you.
Thank you. Court calls case People versus John Marks.
David I. Goldstein, appearing on behalf of the defendant.
Your name?
John Marks.
Thank you.
We're setting this matter for exam, Your Honor. I do have discovery.
People have their witnesses available March 10th.
Do our best, Your Honor.
Preliminary examination in person, March 10th, 2026, 9 a.m. before Judge Washington.
Thank you, Your Honor.
Thank you. Bond continued. Calls case People versus Javante Cadell.
Morning, I'm Rob Dickel on behalf of Mr. Cadell.
Another adjournment underscores logistics over drama. Lawyers need discovery, schedules clash, witnesses travel. Time becomes currency, buying preparation or pressure. For defendants in custody, delays cut deeper. The courtroom rhythm slows briefly, but stakes quietly rise as calendars slide forward toward hearings that decide freedom and futures soon, very fast.
Javante, would you state your name on the podium? My name is Javante Cadell. Judge, we're asking to set this matter for exam.
Discovery is complete.
Yes, sure.
People have their witnesses available February 10th.
Judge, may I address bond?
Preliminary examination in person will be set February 10th, 2026, 9 a.m. before Judge Freshour. Esteban.
Judge, this young man's 18. He has no criminal record. It's my understanding he was living at Ozone, who was trying to place him with his own apartment. I understand there's a $10,000 bond because he missed a court date. He did not have a ride at that time. What I'm asking the court is, I've spoken to this young man. He promises to appear for all future court hearings. He would like to get back to the ozone so he doesn't lose his place as far as getting a placement. And he can be gainfully employed. We would just ask the court to set a PR bond in this matter.
Any response from the people?
Your Honor, I'll leave it to the court's discretion, but if it helps the court decision making at all, the co-defendant's case and was set for a claim on Tuesday and got dismissed because we were unable to proceed at that time.
Got it. How do you come back into custody?
Were you arrested or did you?
I was arrested, sir. My caseworker was supposed to call due to the weather conditions. He said he called, but I guess, but I was picked up, sir.
What were you doing when you were picked up?
Trying to get to one of my friends' house. But sir, I tried to make it to court. The weather conditions was hard. I ain't have a phone. It was cold. My phone died, sir. And I tried to my my caseworker, he tried to help me too, make sure I made it to court, but he couldn't help me.
You grew up in Michigan?
You said what, sir?
Did you grow up in Michigan?
Yes, sir.
You're gonna appear for all future.
It was too cold and we're getting soft.
Nah, it wasn't even just that. I didn't have the right clothing either, sir. And I was willing
I
to
got
walk
you. I got you.
through the distance.
I
with
got
my
you.
hurt.
Well, reinstate his previous bond. I'll grant the reduction. Reinstate his previous bond, but you better show up on the 10th. You hear me?
Yes, sir.
You got to start out walking on the 9th. You better show up on the 10th.
Yes, sir.
You call me, okay?
No, sir.
Let me just see real quick.
So his previous bond stated.
See right away here, boss.
Thank you, Judge. Appreciate your consideration for this young man.
Court does call the case People versus Gary Coward.
Morning again, you're from son of a court date on behalf of Gary Coward.
Gary Coward.
Your Honor, myself and Mr. Chavalowski are trying to resolve it at the district court level. If I can come back on the 12th, I'm back here again, Judge.
Probable cause conference without objection will be adjourned February 12th, 2026, 9 a.m. Bound continue.
Thank you, Your Honor. Text you.
Court calls the case of the People versus Caitlin Quinn.
You were right, I was wrong. Morning, Your Honor, for the record, Brian Stacy, P 33014. State your name.
Caitlin Quinn.
All right, I have before me a plea form that indicates that she's going to be pleading guilty to the charge of use of methamphetamine, the 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the.
That's accurate, Judge. I have had an opportunity to explain to my client her rights in detail. I believe she understands them and at this time knowingly, voluntarily waive them and lay a factual basis to the added count.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Caitlin Quinn.
I mean, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. In understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
You understand by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct? Or had one signed over your hand?
Yep, yes, Your Honor, yeah.
All right. Any question regarding any of those rights?
No, Your Honor.
You understand you're giving up those rights on that form.
Yes, Your Honor.
Particularly the rights contained in paragraph 5. If you look on the podium, you'll see a copy of the advice of rights. Understand you're giving up those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal outright?
Yes, Your Honor.
Are you on probation or parole?
No.
All right. Has anybody promised you anything other than what's been stated here today to get you to plea?
No, Your Honor.
Anybody threaten you or coerce?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of September 4th, 2025, Washington Hogback Road, Pittsfield Township, Washington County, State of Michigan. Did you have methamphetamine in your possession?
Yes, I did, Your Honor.
Did you use it?
I did, Your Honor.
And did you know what you were using was methamphetamine?
Yes, I did, Your Honor.
Ma'am, if I accept your plea, I have to advise you that if you commit misconduct between, as defined by the Michigan court rules, between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Defense is not aware of any, Judge.
All right. And have I complied with the court?
And the defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1. Probation sentencing will be set for February 11, 2026, 9 a.m. That's before me.
And that's here, Judge, correct?
That is correct.
And Your Honor, can I address bond?
Briefly.
Judge, briefly, my client has no prior offenses. The test did come back, the one that she appealed, and it showed the progress report. It said the victim's report negative for fentanyl. And I think that was one of the issues that the court kept her. And I think she would acknowledge that she did use cocaine after.
Well, go ahead, Counsel.
No, and I think she would acknowledge that she used cocaine after being placed on bond initially when you put her in jail. She's been in jail since January 8th. And she also, Judge, has been diagnosed. She was taken to the hospital while in custody for gallstones. Apparently, she does not have any gallstones, but she has blood in her urine, and the doctors believe that she has kidney stones. So she does need medical attention. And she was hoping to, her daughter's 15 years old, she's homeschooled, and her grandmother is 86 years old, and she's been diagnosed with Alzheimer's, and she was hoping to move in with her, and her daughter would be with her and help take care of her grandmother. Her mother, I believe, is.
Are you going to be able to test clean if I let you out?
Yes, sir. I have learned my lesson, Your Honor.
I'll reinstate her previous bond with the testing, and so she'll be released on PL.
Thank you very much for your consideration today, Judge. You have a good day.
You do the same.
Thank you.
Court does call the case People versus Jennifer Burnside.
Morning, Your Honor. Jason Hagelfon on behalf of defendant Jennifer Bernstein, who's present. Standing.
Morning, Your Honor.
Good morning. Your name?
Jennifer Burnside.
All right. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of operating while intoxicated, second offense, the 1 year. On her successful plea to that charge, counts 1 and 2 would be dismissed. Defendant agrees to enroll and participate in the 14A sobriety court. There's also a sentence agreement. Well, it just says the 14A, it says A3, but it's 14A sobriety court. Defendant has been accepted as of January 29, 2026. That's, and there is a sentencing judge where we checked off. That is the court's full understanding of the agreement.
Yes, Your Honor. Yes.
May I have her sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
State your name, please.
Jennifer Burnside.
All right, ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor punishable by up to 1 year incarceration, up to $1,000 fine plus court costs. The court could order any rehabilitative services or community service the court deems necessary. The court could also order your vehicle forfeited or could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
I do, Your Honor.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 1483 District Court. You understand that?
I do, Your Honor.
Bond debates expose real-world constraints, testing fees, employment, housing, and compliance. Judges weigh safety against fairness, granting reductions or remand when stories fail. One misstep can spiral. Accountability isn't abstract here. It's measured in dates, dollars, and the ability to show up consistently under supervision and scrutiny by the court.
You wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty?
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I do.
You signed an advice of rights form, is that correct?
I did, Your Honor.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that.
I do, Your Honor.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
No, I am not.
Has anybody promised you anything other than what's been stated here today to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily
I am, Your Honor.
of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
April 10th, 2025, at the location of I-94 near Freer Road in Sylvan Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, you consumed, I guess, alcohol and cocaine
I did, Your Honor.
and THC also.
Yes,
Is that correct?
Yes.
All right. Were you stopped by the police?
Yes, I was.
All right. Why'd they stop you?
My turn signal was burned out when I went to go get on the highway.
All right. Were you arrested?
I was, Your Honor.
Were you taken to the hospital for a blood draw?
I was, Your Honor.
And what were the results of that blood draw regarding alcohol?
0.97, 0.097.
0.097. All right. Did it also show the presence of cocaine or its derivatives as well as THC and or its derivatives?
Yes, Your Honor.
All right. Do you have any reason to dispute those blood test results?
No, Your Honor.
All right. And ma'am, had you previously been convicted of operating while intoxicated on or about June 25th, 2023 in the 53rd District Court and operating while impaired on or about February 25th, 2006 in Farmington Hills District Court?
Yes, Your Honor.
All right. Ma'am, if I accept your plea, I do have to advise you to commit misconduct between the time I accept your plea and the time of sentencing in this matter, that you would not be entitled to withdraw your plea and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No.
All right. And have I complied with the court?
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 3, excuse me. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A3. Probation. Sentencing in this matter will be March 9th, 2026, 9 a.m. before Judge Freshour. Bond will continue.
Your Honor, I did have one request renewed from the last time we were here. Ms. Burnside has a pretty severe cut. I know the probation, the testing facility, Keith over there had checked that he has recommended her, and I believe he's going to accompany her to medical for that. They did switch the leg, but based on that, would the court be willing to transfer to the sober link and a release of that tether?
Response from the people.
Judge, we'd ask, being a photo manager in the next going to this Friday court, we'd ask that the tether remain. If the court is willing, Mr. Heaton did give us a possible sentencing date of February 12th, and then Judge
That date can be moved up. I'm not moving it up because I don't have a date. So you guys can do that, and if you can get it moved up, then That's fine, and I'm not gonna remove the tether. Her bond will continue as is. Thank you.
Thank you, Your Honor.
I just need a form on that. Court does call the case People versus Marquetta Clements.
Good morning, Your Honor. Assistant Public Defender Alexis Zerbs with and on behalf of Ms. Clements, who's approaching. Can you please state your name for the record?
Marquetta Clements.
Thank you. You're requesting an adjournment?
Yes, Your Honor, to engage in some plea discussions, and I'd like to address bond when appropriate.
Probable cause conference will be adjourned February 12th, 2026, 9 a.m. As to bond.
Thank you, Your Honor. Ms. Clements is in custody based on a prior failure to appear at a probable cause conference on September 11th. It's my understanding that after this alleged incident took place, she was hospitalized at St. Joe's, and then St. Joe's transferred her to Stonecrest, and she was in Stonecrest from September 9th to September 26th. She was suffering from long-term memory loss. She had a concussion, and she was having some other mental health issues. I did try reaching out to both of the facilities. I sent releases of information to both. I haven't gotten any records back at this time. But once she was released from Stonecrest, she was working relief harm reduction. She can either stay with a friend in Ann Arbor, Your Honor, or she can stay at the Delonis. She does provide me this address. And
how'd she come back into custody?
How would you call that?
Officer just took me off the bus, no reason. I wasn't in no trouble.
So, Your Honor, I believe in that.
He just came on the bus and grabbed you?
Ask Officer Lawrence, he did.
Because he knew you had a warrant.
He knew I had a warrant, but I didn't know I had a warrant at the time.
So, Your Honor, with that, I would say that there was no new charges when she was brought into custody. It was just officer recognition and being aware that she had the warrant, so they brought her in on the warrant. Like I said, Your Honor, I'm still waiting back on any of those records, but at this
So I
moment,
don't have any medical to verify what you're saying, and she was gone for about 4 months.
yes, Your Honor, but I'm hoping those records will be here very soon. Like I said, I sent releases of information to both
But
St.
those
Joe's.
records aren't going to explain the 4 months. No answer needed. I don't need a response. Motion for bond reduction denied. Bond voted. Thank you. Court calls case People versus Abdul Latif. You know what? You keep talking. You want me to up it? Oh, give me the file. She wants to be smart. You can just let her know her bond's revoked. Mark the file. Court calls case People versus Abdul Latif.
Morning, all.
Good morning, sir.
Assistant Select Senator Daffy Lebo, now Mr. Latif. Mr. Latif, can you tell the court your name, please?
You need to take your hand out of your pocket. Anything you want to say to me? No, I'm kidding.
Your Honor. Your Honor, we're going to be reflecting an adjournment with no complications in order to just finish verifying some discovery.
Just trying to verify. Okay. I will adjourn this then February 12th, 2026, 9 a.m. Bond continues.
Thank you very much, Your Honor.
Thank you.
There you go.
Thank you, sir. Court calls case People versus Joseph Griffin.
Your Honor, people.
You got that file, Mark.
Good morning, Your Honor. Veronica Glenn requesting permission to practice under pursuant to Michigan Court Rule 8.120, practicing under assistant.
How many times have you
defender.
said this? Come on. You're with Canon, right? Is this the stage fright that's just going through? No? Start again.
Okay. Veronica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120, practicing under Assistant Public Defender Stephanie Cannon.
See, wasn't that hard? He's a product. Yes, absolutely. Permission to practice is granted.
Thank you. Your Honor, we're requesting adjournment in this matter.
All right. Purpose of the adjournment?
We need additional discovery, or we need a discovery.
You need it.
Yes.
Conference without objections adjourned February 12th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the case of the People versus Diamond Buyers. All three cases.
Morning, Your Honor. Raymond Cook for the people. Morning, Your Honor. Edward Lucas on behalf of Diamond Buyers.
Diamond Buyers.
Thank you.
Your Honor, there's some negotiation going on. There is another case that just is authorized, and then there's another one coming down the pipeline. That's what I was told yesterday. I'm looking for an adjournment.
So, Your Honor, there was another case of financial transaction device authorized on the 26th by our office. There's also one pending in the warrant queue. These all stem from roughly the same time period.
So I've got one. Do we have a date set on the one that was on the 26th?
I don't believe so. Let me check my court to confirm that, but I didn't see one when I looked earlier. No, I'm not seeing if there's any dates set on. I don't know if it's either this one.
Yeah, okay. All right, that's fine. So basically, I could potentially be, I'm expecting one, but then there may be another one, so there may be two.
There's definitely 4 total, maybe a 5th one.
Got it. Probable cause conference, what I'll do is I'll adjourn this out to February 26th, given all of that. I'll need green sheets.
Okay, thank you.
2026, 9 a.m. Her crime will continue. And I guess so that those are tracking, if the other one does get sworn out, she's arraigned on that one. However that may occur, I don't mind setting them out to stipulate to adjourn it to this date. So I'm putting it out far enough. Hopefully we can get all that on one date. Okay?
Thank you.
On continue. Thank you. Court calls the case of People versus Spencer Norton, 2 cases.
Good morning, Your Honor. Edward Lucas on behalf of Spencer Norton in 1768.
And the Assistant Public Defender, Chinaba Chair, on behalf of Mr. Martin in the other matter.
Good morning, Miss Ackers.
Good morning.
So you're sitting there and didn't hear a word from you.
She's been talking to me all morning.
She's been in your ear. Okay, I got you. Okay. What are we doing? In your name, sir?
Spencer Norton.
Thank you.
Looking to set ours for an exam, and I think the other one's gonna come along with it.
That is correct, Your Honor.
Both set for exam?
Yes.
All right. Discovery is complete on both of these?
To my knowledge.
To my knowledge, Your Honor.
And do people have their witnesses available to 10th? Preliminary examination in person will be set February 10th, 2026, 9 a.m. before Judge Garwood. You may.
Plea colloquies slow the pace, demanding clarity and consent. Rights are read, waived, and confirmed on record. The court tests voluntariness, facts, and understanding step by step. It's meticulous, unglamorous, and decisive, because a guilty plea ends trials before they begin, with consequences lasting years beyond today for everyone involved here.
Or does, we're all.
Thank you, Your Honor.
We'll continue. Thank you. Court does call the case of the People versus Adam Atkins.
And the Assistant Public Defender, Chinaba Chair, Your Honor, on behalf of Mr. Adam Atkins, who is approaching. Mr. Adam
Atkins. Thank you. All right, I have before me plea form. Indicates that he's going to be pleading guilty to the charge of use of methamphetamine. The 1-year offense upon a successful plea to that charge, count 1 would be dismissed. I would need to check the box on here, understanding
Please.
that I'm a different sentencing judge.
That's correct, Your Honor.
understand, sir?
I reviewed that with him, but I failed to check the box. I apologize.
Well, I knew it was your fault. I just want to make sure that he.
Yep.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name, please.
Adam Atkins.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine, the one that is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Garwood in the 15th District Court.
Yes, Your Honor.
Still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
Guilty as charged.
All right. You understand that by pleading guilty, you'll not have a trial or of any kind. You understand?
Yes, I do.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll have those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes, Your Honor.
Pardon?
Yes.
You are? Were you on probation at the time of this offense?
Yes.
All right. You understand that this could be considered a violation of that?
Yes, Your Honor.
If it is considered a violation of that probation, you could be sentenced to the maximum allowable under those other charge, under that other charge or charges. You understand that?
Yes, Your Honor.
And understanding that, you still wish to plead guilty to this charge.
Yes, I do.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily?
Yes, I am.
Of your own free will?
Yes.
And also because you believe that you're indeed guilty of this offense?
Yes, I do.
On November 20th, 2024, at the location of First Street near Ann Street in the city of Ann Arbor, Washington County, state of Michigan, did you have methamphetamine in your possession?
Yes, Your Honor.
Had you used it?
No.
You were intending on using it?
Yes.
You knew what you had in your possession was methamphetamine?
Yes.
All right, I can take to the higher charge in any
Thank you,
event.
Judge.
All right. Sir, I do have to advise you that if I do accept your plea, if you commit misconduct as defined in Michigan court rules between the time of my acceptance of your plea and the time of your sentencing, the court would not be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, I do.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
We are not, Judge.
And have I complied with the court rules?
Defense is satisfied as well.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be February 17th, 2026. What time? I'm sorry. 9 a.m. before Judge Garwood. Bond will continue. All right.
Thank you, Your Honor.
Thank you. Court calls case People versus Austin Bryan.
Morning, Your Honor. Kevin Nagel appearing on behalf of Mr. Bryant, who is appearing to my right. Your Honor.
Name, sir? Austin Bryan.
All right. Your Honor, I spoke to the people in this matter. I've informed my client of his rights to have a preliminary exam today. We're waiving the preliminary exam, and we'd like to find it over to circuit court here.
Sir, is that a correct statement? You're waiving your right to a preliminary examination?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right?
Yes.
Preliminary examination having been waived, defendants bound over to circuit court on all 3 counts. Counsel, you acknowledge receipt of the information waiver treaty?
Yes, Your Honor.
And at this time, how does your client plead? Is he standing mute to the charges?
Yes, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to all 3 counts. Pretrial will be set for February 10th, 2026, 1:30 before Judge Cuffey.
Thank you, Your Honor.
Bond will continue. Just gonna need to sign off on you. Whoever, I don't know. Court calls the case People versus Ashley Albert. Who had that last case so that we can sign off on the information? I did.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with on behalf of Ms. Albert.
Your name?
Ashley Olber.
All right. You're requesting an adjournment. You just got discovered.
Yes, Your Honor.
Probable cause conference in this case will be adjourned to February 19th, 2026, 9 a.m. on continue.
Thank you, Your Honor.
Court calls the case. Johnny Kane.
For the people. Morning, Your Honor. Michael Gaddy, Assistant Public Defender on behalf of Mr. Payne, Your Honor.
Her name, sir?
Johnny Charles Payne.
Your Honor, this is a matter we have reached a resolution. I'm looking for the paperwork now. I just had in my hand. Here it is. Your Honor, Mr. Payne will be pleading guilty to an added count 2 of use of a controlled substance. I have him executing the plea form and the advice rights. Now, I have gone over his rights. I have gone over his rights with him. Get it. And explain to him that all those rights. Your Honor, this is a matter with some labs. There was a true narc analysis. I've seen a picture of the analysis. I don't have the report. I don't know that the labs have gone to the crime lab. I've explained that to Mr. Payne. He still wishes to issue a plea, enter a plea, if I may approach.
You may.
He is on parole, Your Honor. I've explained to him.
Get to it.
Thank you.
The plea form that the court has in its hands indicates that the defendant's going to be pleading guilty to an added count 2 of use of methamphetamine, that the 1-year offense. Upon the successful plea to that charge, count 1, the possession charge would be dismissed. There is prosecutor and defendants agree to a sentence of time served. However, I would indicate that taking the plea, I could not find a sentencing judge to that recommendation. And that, sir?
I do, Your Honor.
All right. May I have him sworn?
Solemnly sworn to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Johnny Charles Payne.
Sir, it is this court to understand you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Do you understand that, sir?
I do.
You understand also that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court.
I do.
Still wish to plead guilty?
I do, Your Honor.
And to that charge, how do you plead?
I do plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
I do.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights contained on that form.
I do, Your Honor.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation?
No, sir.
Are you on parole?
I am.
You understand that your entry of a plea in this case could be a violation of that parole?
I do.
You understand that as such, you could be sent back to do the remainder of your term?
I do.
Understanding that, do you still wish to plead guilty in this charge?
I do.
In this case?
I do.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
They have not.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily?
I am.
Of your own free will?
I am.
And also because you believe that you're guilty?
I do.
All right. On the date of December 12th, 2025, location of Barton Drive near Pontiac Street, City of Ann Arbor, Washtenaw County, State of Michigan. Did you have methamphetamine in your possession?
I did.
Had you used it?
I had.
And did you know what you were using was methamphetamine?
I did.
All right, sir, I do have to advise you that if between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
All right. Counsel aware of any other promises, threats, or other inducements which have led to this plea?
Defense is not, Judge.
All right, and have I complied with the court rule?
Yes, Your Honor.
Defense is satisfied the court has complied with the court.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. The pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be February 27, 2026, 8:30 before Judge Perry. Bond will continue. Thank you. Thank you, sir.
Thank you, Your Honor.
You're welcome, sir. Court calls the case, People versus Renee Andrews.
Andrews will be preparing on behalf of the people.
Assistant Public Defender Dottie Lee on behalf of Ms. Andrews. Andrews, can you tell the court your name?
Yes, Renee Andrews.
Thank you.
And Your Honor, we're going to be requesting an adjournment. Ms. Andrews is going to be reviewing some discovery with me.
Probable cause conference will be adjourned to February 19th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls cases People versus Kimberly Robinson.
Veronica Glenn on behalf of Ms. Robinson. Can you please state your name for the record?
Shirley Robinson.
Thank you.
Thank you. Your Honor, we're requesting an adjournment in this matter.
I have a green sheet. So that I can. Basis.
Discovery.
Probable cause conference will be adjourned February 12th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Case of the People versus Jessica Anglin.
Good morning, Your Honor. Assistant Public Defender Alexis Zerps on behalf of Miss England. Your Honor, I was unable to get into contact with Miss England. We don't have good contact information from her. It's my understanding that she has some housing insecurities, so I'm not sure if that played a factor into her not appearing today. For the record, I'd be asking for an adjournment.
Does that play a factor in not going to community corrections too?
Possibly, Your Honor.
Oh,
It is very cold out there. I'm sure she's trying to stay
it's
warm.
not cold. This is Michigan. Suck it up. Bench warrants will issue for the defendant's failure to appear. Bond will be set in the amount of $25,000 cash surety. That warrant, those warrants will issue immediately.
Understood, Your Honor. Thank you.
Final gavel energy fades, but repercussions persist across courts, calendars, and lives. Today showed how procedure shapes outcomes faster than speeches. If you value clear breakdowns of real hearings, subscribe, like, and share. We'll keep translating courtroom moments into insight you can trust every day, with accuracy and context guaranteed.